Now with more, Alan Dershowitz, Harvard Law professor, emeritus, and author of the new book, Electile Dysfunction, which is fun and all the things you're thinking it is. Great to see you, Professor. So this guy Kennedy was very actively involved in trying to cover Hillary's tracks, is how it looks. And when the FBI agent involved said, we can't change the classification on this document, thank you for your offer, but we can't, he went above the guy's head, and he went to the head of the FBI's counterterrorism division, Michael Steinbach, and to Steinbach's credit, he refused. He said, I'm not doing this. You don't control us, sir. And the email classification stays the same. So you tell me whether old Patrick Kennedy can face any legal consequences for his deeds.
Well, certainly this raises policy issues, and it's a fair point for any voter to think about. But I searched the criminal code today, and I could not find any possible criminal statute that was violated, despite Donald Trump's statement that this is a, quote, felony crime. Agencies negotiate with themselves all the time. Presumably, if the classification were changed, Congress would know about that. They'd see the original, they'd see the change. No, I understand that, but they would have seen the original, so it's not an obstruction of justice or not a defiance of the subpoena. And interagency quid pro quo is very common. You find agencies saying to each other, all right, I'll do this for you, you do this for me. For it to be a crime, the quid pro quo has to give something personal. Yeah.
When there's a pending subpoena, I mean, the subpoena was in. They had to produce the documents.
That's right.
And there's Kennedy, who works for us. He works for you, and he works for me.
And
works for the viewers. Instead of looking out for our interests, he's looking to protect Hillary's back, saying, we got to get this classification changed. Here's a bunch of goodies if you'll change it.
And that's a fair point, as a policy point of view. From a criminal point of view, however, as long as there was no intention to prevent Congress from knowing that the original classification was to be classified, and then it was changed, if that would have happened for a public release, for a FOIA release, that would not be a crime. You know, it's very easy to throw around the term crime, and I think too much in our politics, we tend to criminalize policy differences, and I'm always against that, whether it was Governor Perry of Texas or Tom DeLay when they tried to go after them because the Democrats didn't like them. I was against that. We have to be careful to make sure the criminal law is only applied objectively by neutral career politicians, and nobody should be... Go ahead.
Giving you that point, you tell me as a lawyer whether what this guy Kennedy did smells bad and whether there should be some sort of accountability in your judgment as somebody who studies and knows the law for this kind of behavior after you've received a subpoena.
I think so, and I think it ought to be an internal departmental investigation. You put your finger on it exactly to see whether he was serving the interests of the American public or the interests of an incumbent in office. And that's a fair point to investigate. The point I'm making is let's not jump to using terms like felony and criminal when we feel strongly that a person violated policies. That's a very important line not to go over. That's why I was so upset when Donald Trump said he wants to see Hillary Clinton in jail. I'd be equally upset if Hillary Clinton said, if I get elected, I'm going to investigate Trump University and put Trump in jail. We should not mix politics and criminal justice. We have to keep criminal justice objective and apolitical.
Fair point. Professor Dershowitz, great to see you.
Thank you.